Mr. Hofmansky, thank you very much for making time for VOA today. I'm pretty sure your schedule is very busy today.
Indeed. Thank you very much for the invitation.
Mr. Hofmansky, Putin said that he doesn't really care about the ICC since Russia does not recognize it. What does this actually mean for President Vladimir Putin? I mean, all those warrants that we saw today.
What does really mean for him, I don't know, but I can tell you that from perspective of the International Criminal Court, it is completely irrelevant. According to the ICC statute, which has 123 state parties, 2/3 of the whole international community, the court has jurisdiction on over crimes committed in the territory of state party or a state which has accepted its jurisdiction. The Ukraine has accepted the ICC's jurisdiction in 2014 and then again in 2015. 43 states referred the situation in Ukraine to the court, which means that they have formally triggered the jurisdiction. And let me stress that the court has jurisdiction over crimes committed by anyone on the territory of Ukraine from November 2013 onwards, completely regardless on the nationality of the alleged perpetrators.
Talk to me more about what it really means for Vladimir Putin in terms of the procedures. You know, is it possible for another state that recognizes the ICC to arrest him if he is, say, traveling outside of Russia?
This is not only possible, it's the legal obligation. According to the Rome Statute, which is the founding treaty of the International Criminal Court, all state parties have the legal obligation to cooperate fully with the court, which covers obviously also the enforcement of the arrest warrants. In practical terms, if the suspect will travel into the territory of the state party, this state party has the legal obligation to arrest a person and surrender this person to the court.
What if the party does not comply with this obligation?
This happened already. We had the case of al-Bashir, which said that there was for already 20 years, and many state parties didn't comply with the obligation. It has the consequences. There are obviously political consequences, but the Assembly of State Parties, the Rome Statute, also the Security Council, in case referred by the Security Council to the court, can decide that the state does not comply with the legal obligation, international obligation, and it has obviously the political consequences. But obviously, nobody can force the state just to comply with the legal obligation from the treaty.
I want to talk about the language of those two cases that the whole world just saw. So basically, we're talking about the war crimes. And there were some certain speculations before by some experts and analysts about usage of the word genocide, but we didn't see this word like in the final documents. Tell me about the choice of the language here.
It is not the issue of language. The genocide, war crimes, crimes against humanity, they are the legal terms. And every term means something according to the Rome Statute. In this specific case, the prosecutor presented the allegation in respect to the crimes, war crimes committed by suspects, and this has been reviewed by independent judges that decided that there is a sufficient reason to believe that these crimes have been committed by these persons, and a result of this consideration, the arrest issued by the court today. But obviously, we have to be aware that it does not close the situation, and this is still in the hand of the prosecutor to fulfill the standard of genocide, as you said. The additional elements, legal elements, need to be met. And in this case, is the requirement of the intention of the alleged perpetrator. It is also the case with the crimes against humanity. The statute, the Rome Statute, described in details what this really means, and it is not necessarily the same what is the genocide or crimes against humanity or war crimes in the mouths of politicians. We use the legal terms as exactly what the court did today.